Good afternoon. I'm Lorne MacLean of the MacLean Family Law Group. We've got 4 offices across British Columbia. Our main downtown office in Cole Harbour, Vancouver, our Surrey office, Kelowna in the Okanagan, and Fort St. John, British Columbia in the north. One of the most prickly topics we deal with as family lawyers in British Columbia is the issue of retroactive correction of spousal and child support arrears. And I'm going to deal today with child support arrears. We handle a number of those cases. We were recently involved in a case where our ecstatic client was awarded nearly $30,000 a month of ongoing spousal and child support payments, but in addition received a substantial retroactive child support award. We base the analysis of correction of child support arrears on the fact that child support is the right of the child. And the right of the child to that support survives the breakdown of marriage, and that child support should, as much as possible, provide the children with the same standard of living that they had when the parents were together, and also in cases where a parent's income goes up, that those children also benefit from the increase in income of the paying spouse. What are the factors that a court will look at in going back to correct the support that the child should have received if there's been an increase in support required from an increase in salary, or whether there should be a correction to decrease the support to bring it in line with the new salary of a spouse who may have lost their job or suffered a cutback in pay? We're going to look at, number one, the circumstances surrounding the delay on the part of the recipient spouse. We're going to look particularly also at the paying spouse's conduct, the circumstances of the child during that period of time to see if that child suffered hardship. And finally, we're going to look at whether the retroactive correction will create an undue hardship on the paying spouse. What do you do to make sure that you promptly correct the support upward, or in cases where someone through no fault of their own has suffered a decline in income, downward? If you're the recipient spouse, you've got to take into account the factors that I've gone through. You should be asking for an inclusion of an annual correction clause into the separation agreement, minutes of settlement, or court order. If you're the recipient spouse, you want to make regular written demands for disclosure of the current income of the paying spouse. You want to make a note of the dates that you made those requests. You don't want to negotiate for too long, and you need to be able to produce proper evidence of why there was any delay. Were you being misled? Were you being bullied? Were you being told that that spouse would take some sort of action against you, such as, I'm going to claim custody of the children, I'm going to try to show that you're a bad parent, etc. If you're the paying spouse, you've got to understand that you have an obligation to support your children and that it changes with your income. You can take a look at our free guideline calculators so that you know what the annual payment should be and based on your income, and it will also calculate what the monthly payment should be for you. And you've got to know that if you fail to disclose, you're going to be at risk for a retroactive correction of that child support. Remember, both parents have the obligation to ensure that fair child support is being paid. Don't sell your children short. I'm Lorne MacLean of the MacLean Family Law Group. You can go to our website at www.bcfamilylaw.ca. Go to our free spousal support calculator, our free child support calculator, where you can enter your annual income and it will spit out the monthly payments that you should be making. And remember that both parents have that obligation to ensure that the children have the best possible standard of living. Thanks for watching. Lorne MacLean. You can also call us anytime toll-free at 1-877-602-9900. Thanks for watching.